But to go back to what's important to understand, a lot of you have obviously done zillions of tax appeals, been involved in that, and tax appeals tend to roll. And in New Jersey, as you all know, October 1st is of the preceding year is the date of valuation for the assessment number. Bankruptcy cases now, this is a different world than when Dan and I started. I'm 30 years. I don't know how many years. You're 25, whatever. We're younger than we look. The cases are compressed. So, hypothetically, Crown Plaza files bankruptcy on October 31st of this year. The issues that are going to come before Judge Kaplan on this bankruptcy case are going to percolate pretty quick. So you could start with that if you were the lender, if you were the bank that had financed this hotel and was owed $15 million, what's going to be relevant to Judge Kaplan is going to be that the evaluation be fairly current to that date. So if the bank wants to say, I'm owed $15 million on this hotel, and this hotel hasn't paid me any debt service in a year and a half, and it was on the verge of the sheriff's sale, and this bankruptcy is just aimed at prolonging and praying for a white knight and all the things that we know bankruptcy is used for, what Judge Kaplan is going to want to know is boots on the ground. He's going to want you to pick and under our local rules here, there's a requirement when the bank moves to lift the stay to finish the foreclosure that an appraisal be submitted. So he's not going to want to look at an appraisal from 2 years ago.
Well, let's talk about it, and let me just
go ahead.
The statute. It's always a good place to start with the law. As far as in a second, the proper valuation date.
And this, by the way, is the second opportunity for appraisers to get involved. The first would be the petition. Now we're talking about stay relief.
But what date do you pick? As I said before, there's three options: the date of the filing of the bankruptcy, the date of the hearing of whatever issue is, and maybe a date of a confirmation of a plan, which could be 2 years down the road. What the code says, bankruptcy code, this section says, you determine value in light of the purpose of the valuation and of the proposed disposition of or use of the property. So that if the value is relevant early on in the case, because the bank wants relief from the automatic stay to continue, then you're looking for, most likely, what is the purpose? So the bank can foreclose. So the value may be tethered to a forced sale situation, and you're going to pick the date right around the beginning of the case, the petition date. Maybe the hearing date, but it's so close, it shouldn't be a difference. If the petition is filed on October 1 and the hearing is November 5th, tell me that the value of that property is going to change between October 1 and November 5th. Unlikely. But if the use of that appraisal, the value is tethered to confirming a plan and showing that this property, this commercial office building, can support a new loan over the next 30 years, and the income would support it, doesn't matter what it was 2 years prior on the petition date. It's at that point. And that's why there's the flexibility built into the code as to what date. And there are law review articles this thick, and there are cases which go either way. But mostly the court is going to look to what is the purpose of the valuation? What is the nature of the hearing at which it's being brought up? And what is the use of the property? Is the debtor going to keep the property? Is it going to be sold in a liquidation? And that will govern not only the date, but possibly the standard for valuing. Now we'll go right here.
Just getting back to the exemption, the personal exemptions. First, second, and third mortgage still get paid before those. How about judgments that the debtor had before?
If they're deemed a secured claim, there are ways under state law for a judgment to be deemed a secured claim and not. So if it has been perfected before the petition date, then the judgment creditor is an allowed secured claim and would get paid ahead of exemptions.
As a rule of thumb, in New Jersey, judgments aren't perfected until a writ of execution is actually issued. Just because you get a judgment and it's docketed with the court, it sits there. But until a writ of execution and that execution is served on the judgment debtor, it's not perfected. So that judgment holder is really simply an unsecured creditor. No different than American Express or a doctor bill or anything else.
Which is a big difference from New Jersey state law. If you get a judgment in the Superior Court of New Jersey and you docket that in Trenton, and that real estate is subsequently sold, you will be paid. That judgment is.
It's a lien on the
It's a
property.
lien under state law. If, however, that property is sold in a bankruptcy setting, if you have not perfected that judgment by the writ, as the judge just mentioned, then you are an unperfected and an unsecured creditor.
There was another question behind, yes.
Yeah, my question is, if you're asked to do it in the beginning, like you said, the purpose of the appraisal is to see what it's worth, and it's done on the petition date. Now, 2 years later, they've come up with this plan. You've got to redo your numbers?
Yes.
Okay, so you're going to be in for another assignment. Do you go through the entire process again, application to be paid, and the court approve all this?
I
Or does
would.
it continue?
I would, unless the original retention, which I doubt would be easy and it would have occurred. I've never seen it occur, where you hire an appraiser kind of like on an open retainer. My strong sense would be to protect yourself on payment or whatnot, would be to do the process again. You know, again, unless the original court order, I've not seen it, unless the original court order contemplated this second
Scenario.
appraisal, I would not take it as a given.
It usually will just contemplate an appraisal
Exactly.
and then testimony.
Exactly.
Now, that appraisal that was initially provided as part of a prior hearing, one of the ironies that you see in a bankruptcy proceeding is that strategy changes, motivation changes, and the needs of the parties change during the course of a case. Figure a case 2 years old. In the beginning of a case, in a corporate case, let's talk about an office building or a hotel that is underwater, there's a foreclosure, the debtor files to Chapter 11 to try to fend off the foreclosure. Immediately upon the filing, what's going to happen is the lender wants to come in and establish that they're entitled to relief from the automatic stay to continue the foreclosure. They're going to argue, Judge, this property is losing value, we're not adequately protected, which Dan will talk about. There's no value here. Look at the mortgages, look at the liens, look at the value, here's our appraisal. There's no value, grant us stay relief, let us continue the foreclosure. The debtor is going to come in, or a creditors committee, or both working together, the few times they actually agree on something, to fight off the secured creditor. They're going to come in and say, oh no, Judge, this property has substantial equity. This lender is protected. They don't need to foreclose now. They're owed $10 million, but the property's worth $15 million. We have an equity cushion. Do not grant them stay relief. That's in the beginning of the case. That's your typical battle in the early stages of a case. Now fast forward, 2 years down the road, the debtor's trying to confirm a plan. And the debtor knows that in its plan they have to treat this lender. And one of the tools in a Chapter 11 is cram down, the ability to reduce the amount of the secured claim to the value of the property. And suddenly they're arguing, Judge, we're proposing a plan, and this plan is going to provide to pay this lender in full over 10 years, amortized out. What do you believe the property's worth? Well, we actually think this property's worth $7 million. So they have a $7 million secured claim, and yes, they're owed $15 million. They have an $8 million unsecured claim. That unsecured claim is going to get paid 5 cents on the dollar. But the secured claim has to be paid in full. So this same debtor, this same attorney, this same party, 2 years earlier argued the property was worth $10 million, is now arguing, or $15 million, is now arguing it's worth $7 million. Now, I'm not stupid, at least some say that. I remember what went on. I'm not bound by that. If I ruled that it was worth $15 million earlier on, I can find that it's worth $7 million now. But I'm only going to do that if somebody actually proves it to me. I have an appraiser telling me why that first appraisal was wrong, or if it's not wrong, why the market's changed and why the value is now. It's a matter of proof. I'm not bound by an earlier appraisal. The question was, do you start with an earlier appraisal? It's evidence. Believe me, the bank is going to come in if the debtor has changed appraisers and suddenly there's a new witness at the confirmation hearing that bank is going to come in and subpoena the first appraiser and explain what happened. It's evidence, I will hear it. But in a bankruptcy, you're going to see these shifting motivations. You'll see changes in strategy, and it's very fluid. And it seems somewhat inconsistent, and sometimes you wonder, are we in Alice in Wonderland?